This is Michael Popok, Legal AF. Did Donald Trump overinflate fraudulently the value of his assets and his personal financial statement by almost $4 billion? And then when he wanted to save on taxes, deflate all of those numbers? That is at the core of the New York Attorney General's civil fraud case brought in New York State Supreme Court, and it had a major hearing today. Why are we talking about it before the October 2nd bench trial, which may or may not be going in October, depending upon what an appellate court decides? Well, while the appellate court makes its ultimate ruling, and they'll have a hearing next week, starting on Tuesday or Wednesday, on the issue of what day the trial is going to be, the parties are duking it out in the trial court level in front of Judge Engoron. And today was summary judgment day. That was the day that the judge heard oral argument based on briefs that were already filed as to whether, as a matter of law, without the judge even having to conduct a trial with live witnesses and evidence at all, whether Letitia James, the New York Attorney General, has met her burden. It's a civil burden, preponderance of the evidence, that there is an ongoing fraud going on at the Trump Organization involving personal financial statements, fake appraisals, value of property, inflation of property, and deflation of property, right? That kind of shell game. And both parties, the lawyer that was up there for the New York Attorney General, the lawyer, Chris Keiss, that was up there for Donald Trump, they both used, it was weird, they both used the through the looking glass Alice in Wonderland motif to make out their arguments. Here's the arguments from the New York Attorney General inciting the fact that effectively Donald Trump has misplayed the market, undermined fairness in the market by borrowing more money than his organization was entitled to borrow under normal lending standards because he overinflated, based on nothing but his own mind, the value of his property, borrowed against that. Yes, he repaid it. But the argument of the New York Attorney General is this isn't a victimless crime. When you borrow more money and commit mortgage fraud, then the assets securing it can support. You've done a couple of things. One, you've left the balance sheet of the bank in a precarious situation because if you don't pay the loan, even though he did, if you don't pay the loan, there aren't assets sufficient, right, if liquidated, to pay and support the creditors and the investors and the depositors of the bank. So you have destabilized the bank because they think they have one set of loans and assets on their balance sheet when they really have a much smaller set. That's one. Two, you've overborrowed. For every dollar a bank loans to one borrower, it is a zero-sum game. That's one less dollar that bank has for another borrower. So if Donald Trump is up there at the trough like a pig, lapping up all the dollars based on fraudulent inflated property value, which is normally at some sort of what's called loan-to-value ratio lending. In other words, you can't borrow 100% of what the value of your property is. You can borrow maybe 70% or 80%, depending upon the interest rate. But the loan to value, the loan is on a value, and that value is generally appraised value. And Donald Trump, as the New York Attorney General said in court today to support their, we don't need a trial, find them liable for civil fraud right now on the record, in that argument, said Alan Weisselberg, the CFO for the Trump Organization, has already admitted, for instance, of one of the 12 properties, trophy properties of Donald Trump that's part of this case, this fraud case, is his own apartment at Trump Tower. And Donald Trump claimed in borrowing that it was a 30,000 square foot apartment, which, for those that don't follow square footage in apartments, that is gigantic. That would effectively be the largest apartment in the city of New York, in Manhattan. Alan Weisselberg, the CFO, said, oh, that was a mistake. It was only 10,000. I mean, come on. That's a big miss. 300% miss? That's a huge miss. And he was able to borrow money based on the fact that there was a fraudulent number being used. Now, Donald Trump also, and this was shown in court, also signed and attested in his certificate. Donald Trump himself, not one of his lackeys, not the CFO, certified that he was responsible. Donald Trump was responsible for preparing the fair presentation of his financial statements in accordance with generally accepted accounting principles. And he also attested that there were actual appraisals that supported these things. Now, the bank should have asked for more confirmation, but they sort of trusted Donald Trump. Chris Keise's lawyer kept calling him a genius today. He's a genius businessman. He's a billionaire because that's how billionaires think. Chris Keise went so far as to try to ridicule the attorney general during the hearing today and say she's not smart and neither is her staff in real estate matters. And if I had $1 to invest in real estate, I certainly wouldn't follow the New York attorney general. I would follow Donald J. Trump. Spoken only like a man who got a $5 million retainer from his client from the Save America PAC, that Chris Keise, who for a long time didn't do much for that money. So yes, he is a brilliant businessman because he's so far been able to fleece his own client. But in terms of the argument in court today, which is what really mattered, you looked at what the lawyer for the New York Attorney General did by putting up the 12 pieces of property and showing just for instances, what the overvalue was for Mar-a-Lago. Let's just take the scene of the crime for the Jack Smith prosecution related to the stolen National Defense Information top secret documents. Mar-a-Lago, according to the New York Attorney General, has been overinflated in terms of price by Donald Trump and value by $500 million. That's not a small miss. That's like, didn't just miss it just by a little. $500 million. 40 Wall Street, which is right near the Federal Reserve in Manhattan, lower Manhattan, that the New York Attorney General says he overinflated over time every year by about $200 million on his books. So let's stop right there. If the only two pieces of property that Donald Trump fudged, cooked, inflated for borrowing purposes were Mar-a-Lago and 40 Wall Street, that alone would be a $700 million fraud. You tell somebody, let's make it simple. You have $1 in your bank account and you own two pieces of property called 40 Wall Street and Mar-a-Lago. You would list on your balance sheet, based on Donald Trump, that you had $701 million, $701 of assets when you only had $1. See the miss? And then add that onto all the other properties. Now, Chris Keise and the crew at Trump have another argument about taking some of the real estate off the board because they say the New York Attorney General was late in bringing the prosecution, or in this case, the civil fraud case, and missed the statute of limitations, and therefore is time barred for bringing these cases in court. And they have some support for that because in June, the New York Attorney, the First Department Appellate Division, which is the first level appellate court above the trial court that we're in, did make a ruling that said to the judge, you better use a scalpel and cut out certain of the transactions that are before a certain date. Actually, 2 certain dates. And when they did that, they also said that Ivanka Trump shouldn't be involved because she wasn't really there after 2017. And so a lot of the transactions sort of fell off the time continuum, the time bar continuum. And so that's what the judge is also doing. And he has already said before trial on October 2nd, sometime next week, I'll let you know which of the transactions of the 12 pieces of property on the board are on the board for trial and which are off. And you're trying the case in front of me. There's no jury in this case because Alina Habba screwed up a form and didn't properly check the box for jury trial and got stuck with Judge Engoron. And that's the way that case is going to go. Now, summary judgment in terms of Chris Keise, which his defense seems to be twofold in terms of his request for summary judgment. Donald Trump's a billionaire genius, and we should just let him do whatever he wants. I'm barely ridiculing his defense. It's basically that. If anybody in this courtroom, Your Honor, would put their money with Donald Trump over Letitia James, New York Attorney General, in a heartbeat, that's where you should put your money. And then arguing that this was a victimless crime, basically, that Donald Trump took out all that huge fund of money, each property that he financed. And even though he took out more than he was entitled to, denying other borrowers their ability to get money because it's a zero-sum game, he paid it all back, so there's no victims, and the banks won't say there is. To which the New York Attorney General and Judge Engoron in court said, just because you paid back the money doesn't mean there's not a fraud here. because you've undermined the fairness in the marketplace, because you're not competing fair and square with the borrower next to you, because the borrower next to you, small business, big business, pension fund, whatever it is submitting real, true appraisals, real, true, reliable financial statements and borrowing at those limits. You're over borrowing because you're doing $3.7 billion of fraud in inflating your personal assets and then deflating your assets when it was convenient for you and you wanted to pay less in taxes. So you're not playing fair, right? You're on a tilted playing field of your own making and you're getting the advantage of it. And that's the civil fraud that the New York Attorney General, through her powers, statutory powers for the state of New York, has the power to stop. That's the argument. In fact, the clerk for Judge Engoron said, are you claiming that since, and this is the clerk, but the judge, kind of let them conduct this part of the hearing. He said, you're not saying that since nobody lost any money that there's no civil fraud here, are you? And Chris Geist basically conceded, yeah, that's what I'm saying. I'm saying that he's a billionaire genius. We should do everything he says. And since he repaid all the money that he borrowed fraudulently, there is no civil fraud. That's like saying in the middle of the night, I went to a bank and I robbed it. I cleaned out all of the drawers and all of the safety deposit boxes in the vault. But like before they caught me, or before my even trial was over for the crime, I broke back in and put it all back. And see, there's no crime. That's sort of the no civil fraud argument. Because they're not recognizing, although they say that the New York Attorney General is undereducated in the area of real estate, I would say that Chris Geist is undereducated in the way that banks, lending, and loans work. Because if a bank on its balance sheet, based on Federal Reserve and Office of Currency and other regulations in the banking world, has a limit to what they can lend over their assets. They have to reserve a certain amount, especially after the collapse of the banks after the crisis in 2007. So they can't lend out everything, and so they get there's a line, right, to see who can get money from the bank, and they can keep lending to people in that line until there's no more money. No more money because that month or that quarter, they can't do any more lending. And if Donald Trump is over borrowing fraudulently, then the bank is under lending to a legitimate borrower that's sitting in that line. That is the fraud. And of course, the lowering the tax base of the property in order to pay less taxes, who gets screwed? The regular taxpayer, because there's less tax receipts coming in because of Donald Trump's tricks. And that's the argument of the New York Attorney General, which is you can't reward them for their elaborate shell game and this inflation and deflation that is going on, right? That is the ultimate argument. And so that was the battle that went on today with the New York Attorney General. And you have comments by Judge Engoron that suggest a couple of things. One, he's not concerned at all that there's an appeal going on right over his head about whether he's done the right thing and whether his October 2nd hard, fast, set in stone trial date, which is literally right around the corner. I mean, it's like in 10 days, that's going to be disturbed by the appellate court and his bosses just above him. He's not concerned about that. There's a separate hearing on it. I'll report on it with the MeidasTouch and Legal AF people when it happens, but that's going to be decided by his bosses at the appellate court, who's going to decide whether there's any reason at all why the October trial should be pushed off. New York Attorney General has already just done her filing that we've already reported on here on Legal AF and the MeidasTouch Network that says if you lose the October trial date, there's due process that's already been provided to the other side. They've had plenty of time to prepare their case. There's no need for additional time delay just because they're waiting on the summary judgment ruling. I mean, the reason that Donald Trump wanted to delay the case is, well, I want to give the judge more time to rule on the summary judgment. Well, the judge already read the briefs. He held the hearing today. He said he's going to rule on Tuesday, day after the Jewish holiday. On Tuesday, Judge Engoron is going to rule on New York Attorney General's summary judgment seeking to have a finding of fraud without trial, the summary judgment brought by Donald Trump's lawyers to have the whole case dismissed, which is not going to happen. Because one of the things that Judge Engoron said today is that just because nobody lost any money doesn't mean the case gets dismissed. And that's the entire lens through which he's evaluating this. And the third thing the judge is going to look at is, because there was in the afternoon, they handled another part of the hearing, which is motion for sanctions. Donald Trump and motion for sanctions just go together like peanut butter and jelly, don't they? Like a camembert and a fine wine. Just think, I don't think there's been a case I've reported on Legal AF or on the MeidasTouch network where we haven't mentioned Donald Trump being sanctioned, filing sanctions. It's usually him on the receiving end of them. And there's another one because he kept filing with these lawyers, Chris Keiss and Alina Habba's old firm. They kept filing these frivolous, already denied defenses and bringing them up again and again right before trial. And the judge says, if you bring it up one more time and you file one more set of papers to bring up defenses that I've already rejected, evaluated, and rejected within my discretion as a trial judge, and you make the New York Attorney General and the taxpayers of New York have to respond to one more frivolous argument, I'm going to sanction you. You've been warned. Now, normally what follows that is nothing. In other words, the lawyer doesn't take a false step and cleans up their act and stops pissing off the judge and violating his orders. But that's not what they did. They went again and Chris Keiss raised a whole other set of arguments that Alina Habba, remember her? Alina Habba had already raised a year ago and it got rejected by the judge. And the judge said, just because you keep saying it over and over again in different settings, in different papers, as if I don't remember that I've already evaluated and rejected it, doesn't mean that's in good faith. That is frivolous. And I'm going to award them sanctions, the New York Attorney General. And that was on display today with the oral argument about it. And the judge got hot there again in reminding them that you have been warned, Mr. Keiss. Your prior counsel, Ms. Habba, have been warned about continuing to raise these frivolous defenses. The judge went so far as today as to say, I thought it was a joke when they were brought up again. Like, this couldn't be happening after I've already warned you not to do that. Just for those that are kind of civilians and don't follow courts or try cases the way I do, it is not normal to keep bringing up dispensed with, ruled upon, and denied defenses and arguments and legal arguments over and over again just because you think it's fun. There's a name for that. It's called contempt of court. It's called getting the book thrown at you. It's getting the ire of the judge up. And it could ultimately end in sanctions. And that's what the judge is going to decide on Tuesday. So the judge has got three things to decide on Tuesday. One is whether he's going to say no trial at all. Civil fraud established on the record, on the papers, on the undisputed facts. No, or no, there's some facts that have to be resolved at bench trial after I hear from testimony. Donald Trump testifying. That'll be a shock to everybody that he shows up to testify. By the way, he's not showing up to testify. Just newsflash on that one. And then whether Donald Trump gets his case dismissed on a summary judgment, that's not happening either. And then finally, he'll rule on the sanctions on Tuesday. We'll report back on what Judge Engoron does, waiting to see while the appellate court moves forward to decide whether the October 2nd date stays in place. And we find out on Tuesday whether there's going to be a trial or the New York Attorney General has won on the papers, so to speak, and there isn't even a need for a trial, which will lead to another set of appeals. We'll do that one place where I sit at that valuable real estate, continuing our theme today, at the corner of law and U.S. politics. I do it in one place. I do it at the MeidasTouch Network on their YouTube channel. You knew that. You're here now. Help them get to 2 million free subscribers. The bigger they are, the more powerful they are, the more your voice resonates. And then we pull it all together Wednesdays and Saturdays, coming right up, in a Legal AF podcast, which is at the law and U.S. politics intersection, just like this, except I got a co-anchor Wednesday and Saturday. Legal AF, it's what you think. And we do that on Wednesdays and Saturdays. You can leave me a comment, give me a thumbs up here, helps with my ratings, helps keep my content coming to you until my next hot take, until the next episode of Legal AF. This is Michael Popok reporting.
Hey, Midas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.